Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Today's video is part of our personal stories series. We believe that there is no greater power than one's own voice, and that is why we aim to share personal stories as narrated directly by those who have experienced them firsthand. For example, Brian Buckle and Michael O'Brien used the power of their own voices to share their personal journeys with us. While our goal is for personal stories to be told directly by those who experience them, sometimes this isn't possible, whether due to their passing or other circumstances. In those cases, those stories are narrated either by us, as we did in the case of Sally Clark, or by campaigners, as it was the case of Warren Slaney, who remains in prison. Today's story is about someone who is no longer with us. His story has been told in many ways, by many means, and by many people. So why are we retelling it? Well, first, every storyteller brings a unique perspective. And today, our focus is on reminding those in positions of power of their duty to uphold justice. This story also serves as a reminder to the public to remain vigilant and critical of systems that can fail. Most importantly, we aim to highlight how, despite the passage of time and the reforms that followed, this story is still relevant today. Its lasting significance will become clear as we go on, so do stay with us until the end for our unique take. So today we dedicate this video to Derek Bentley, a 19-year-old whose life, or rather tragically, whose death was shaped by the reckless actions of an irresponsible 16-year-old on the night of the 2nd of November 1952 and the ensuing injustice that followed that tragic night. Although Derek Bentley's story technically begins on the 30th of January 1933, the day he was born, in many respects it truly begins on the 28th of January 1953, the day he died. After all, it is through his tragic death that Derek Bentley is most remembered. The injustice surrounding his death was a catalyst for significant legal reforms, making his legacy more about the changes that followed than the events leading to it. Today, however, our focus is not on the reforms that came in the aftermath of Derek Bentley's death, but rather on the events leading up to that tragic moment. We aim to highlight the deep injustice he faced at the hands of a rigid, unyielding, and critically flawed criminal justice system, one that too often still today turns a blind eye to the truth, refusing to acknowledge its own failings. A system marked by its stubbornness and inability to confront obvious errors. In Bentley's case, this refusal to listen or act with compassion had devastating consequences, illustrating the dangers of a legal system that prioritizes procedure over justice. We therefore start Derek Bentley's story with his death and the events that led up to it. The following clip that I am about to show is taken from a 1972 TV movie, To Encourage the Others, directed by Alan Clark, based on David Yallop's book of the same title. Please be advised the clip is highly distressing, but it is essential to grasp the irreversible nature of certain decisions and why it is crucial for those who make those decisions to fully understand their consequences.
At 8 p.m. on the evening of the 27th of January, a deputation of 6 MPs presented a petition signed by 200 MPs to Sir David Maxwell Fyfe. They again urged him to reprieve Bentley. The Home Secretary listened to their arguments for 45 minutes, and 2 hours later he informed them of his conclusions.
I didn't tell him. Never told us to shoot that policeman.
Sir David Maxwell Fyfe, Hansard, 1948.
As a realist, I do not believe that the chances of error in a murder case with these various instruments of the state present constitute a factor which we must consider. There is no practical possibility. The Honourable and Learned Member asked me to say that there is no possibility. Of course, a jury might go wrong. The Court of Criminal Appeal might go wrong, as might the House of Lords and the Home Secretary. They might all be stricken mad and go wrong, but that is not a possibility which anybody can consider likely. The Honourable and Learned Member is moving in a realm of fantasy when he makes that suggestion.
This has been the true story of how one teenager moved into that realm of fantasy.
Derek Bentley was a 19-year-old with significant learning difficulties and a history of behavioral issues. His intellectual age at the time of these events was that of an 11-year-old child. It is understood that an accident during his childhood contributed to his impaired mental capacity. His mental shortcomings were well documented by school as well as by the prison system. On the night of the 2nd of November 1952, Bentley and 16-year-old Christopher Craig attempted to break into a warehouse in Croydon, South London. The police were alerted and a confrontation ensued on the rooftop of that building. When the police arrived, Bentley was quickly apprehended, but Craig, armed with a revolver, refused to surrender. The Crown alleged that when he was apprehended, Bentley shouted, "Let him have it, Chris." Craig then fired several shots, one of which killed Police Constable Sidney Miles. As usual, we take a moment to send our deepest sympathy to PC Miles' family for the loss and pain they have endured. Nothing said here can and will diminish their grief. So, continuing with the event of that tragic night, both Craig and Bentley were arrested and charged with the murder of PC Miles, and their trial was held on the 9th of December 1952 at the Central Criminal Court before Lord Chief Justice Goddard and a jury. Bentley denied he ever shouted, "Let him have it, Chris," and Craig confirmed he never heard Bentley shouting those words. Both Bentley and Craig were found guilty of murder on the 11th of December 1952, apparently after only 75 minutes of deliberation. Despite the fact that Bentley did not fire the gun, did not try to resist arrest, did not use a knife and a knuckle duster which were found in his possession, and was in police custody at the time of the shooting, he was found guilty of murder under the legal doctrine of secondary liability or joint enterprise, which held him responsible for the murder executed by Craig. It was alleged by the Crown that his words of incitement demonstrated his intention and participation. They also alleged that Bentley knew that Craig had a gun. Not only they both, Bentley and Craig, disputed to have heard those words, but even if correct, Bentley's statement is rather equivocal, as it could be interpreted either as an incitement to shoot, but equally as an instruction to surrender the weapon. Given Bentley's behavior to peacefully surrender to his arrest and not using the weapons that he had in his possession, the second interpretation should have at least provided a reasonable doubt as to his participation in the murder. Craig was under 18 and thus too young to receive the death penalty. He was sentenced to an indeterminate prison sentence, whilst Bentley, on the other hand, was sentenced to death despite his limited mental capacity. The trial was plagued by numerous uncertainties. There were questions about how many shots were actually fired and by whom. The bullet that killed PC Miles was never recovered, and it was discovered that Craig's revolver and ammunitions were substandard. There was also doubt over whether Bentley ever shouted the infamous phrase, and even if he did, there was uncertainty about its meaning. Was it an incitement to shoot or a command to surrender the weapon? The judge's summing up was so unfair that left no room for the jury. The jury had no alternative but to find Bentley guilty. Derek's mental impairment should have been evident to the police, the judge, and the jury. Indeed, the jury's request for mercy may well serve as evidence of their recognition of this. Bentley immediately filed an application for permission to appeal, but this was refused on the 13th of January 1953. In line with the clip we showed earlier, despite the jury's recommendation for mercy and 200 members of Parliament requesting a debate around the issue, Maxwell 5, the then Home Secretary, decided not to commute Bentley's sentence. Bentley was hanged on the 28th of January 1953 at Wandsworth Prison. Craig served the recommended 10-year tariff and was released in May 1963. The public outrage at the hanging of a man with impaired mental capacity led to changes in the law. The Homicide Act 1957 introduced the concept of diminished responsibility owed to an abnormality of mental functioning. Ultimately, Bentley's case, combined with those of Timothy Evans and Ruth Ellis, contributed to the abolition of the death penalty. However, as we have already stated, our intention is not to remember Derek Bentley for the reforms that came in the wake of his death, but rather for the failure that led to it. We want to focus on the grave injustices that unfolded during his trial and the systemic flaws that allowed an innocent life to be taken. It's important to confront the legal missteps, the ignored evidence, and the bias that culminated in his tragic execution. By understanding these failures, we gain a deeper appreciation appreciation of the broader significance of Derek Bentley's story, not just how a miscarriage of justice occurred, but how disturbingly relevant those same issues remain today. The legal missteps, ignored evidence, and entrenched biases that led to his execution are still as present in the system as they were then. This realization forces us to confront with the sobering truth. Bentley's death was in vain, as the very problems that condemned him persist. Despite the tragedy of his case, it has not impressed upon those in power the devastating cost of negligence, prejudice, and error. His story serves as a stark reminder that lessons we should have learned about fairness, accountability, and the value of human life are still being ignored, and the systemic flaws that led to his wrongful death continue to threaten justice today. The trial, instead of delivering clear answers, only raised more questions. Why? Because the testimony of the police was given more weight than that of the defense witnesses. Because the defendants' testimonies were heard merely to give the appearance of a fair trial, but were contemptuously disregarded as if their voices didn't matter. Isn't this what happened in the post office cases? Key discrepancies in the police accounts of the events were conveniently ignored, and Bentley's medical records, which could have been crucial, were not properly considered. Isn't this what happened to Oliver Campbell? What should have been a careful and thorough examination of the facts was reduced to a 2.5-day farce with life-altering consequences. To call such a process serious will be an insult to the idea of justice, especially when it resulted with the execution of a young, vulnerable man. The troubling reality is that joint enterprise trials today are still conducted in much the same way as they were during Bentley's time. Juries are often left to speculate on too many crucial details when determining the responsibility of secondary participants. In cases where there is no clear evidence of active participation, juries are forced to speculate as to what a suspect may have known or anticipated, just as they did in Bentley's case. Bentley remained peaceful throughout the incident, offering no resistance during his arrest. In fact, there was evidence suggesting that at one point he was even concerned for the safety of the police officers. He never used the weapons in his possession, and this should have been enough to demonstrate that he was not a willing participant in the joint enterprise in relation to the murder. And even if he had initially been involved, by the time he was apprehended, he had withdrawn from any criminal intent. In our video Caught in the Net, Untangling Joint Enterprise, we highlighted how the biggest injustice of joint enterprise is the challenge to demonstrate last-minute withdrawal from joint enterprise. Unlike the principal offender, who can visibly express their change of heart through concrete actions, such as choosing not to use a weapon at the last moment, secondary offenders lack such a clear and direct opportunity to showcase their change of heart. This case perfectly illustrates this point. The judge had a duty to instruct the jury on the significance of Bentley's action after his surrender to the police. Instead, the jury was left to speculate, unsure of the meaning behind the words Bentley may not have even spoken, or to interpret the fact that he had weapons in his possession which he chose not to use despite having the opportunity. They were also left to guess whether Bentley knew Craig had a weapon rather than being guided by clear evidence or context. This lack of direction allowed critical gaps in understanding to be filled with assumptions rather than facts. This is an unacceptable practice in any trial, especially one where a defendant's life or liberty is on the line. The presumption of innocence should always prevail, and any uncertainties should weigh in favor of the defendant. Allowing speculation to replace clear evidence in such cases undermines the very foundations of justice. What makes this case even more outrageous is that shortly after Bentley's conviction, an appeal was filed. Yet the Court of Appeal's rigid determination to protect the integrity of the judicial process led to the dismissal of two well-founded and legitimate grounds for appeal, grounds that 45 years later were finally recognized as valid. This refusal to correct obvious mistakes highlights how deeply entrenched this issue remains. Even today, we see the same unwillingness from the courts to admit errors were made, no matter how compelling the arguments are. The Court of Appeal's refusal during the first appeal to acknowledge the serious failings in Bentley's case is a reflection of a wider, persistent problem within the criminal justice system. Despite the sound legal reasoning, the courts often resist admitting that mistakes have occurred or that misconduct by authorities could have played a role. This pattern continues in modern cases. Consider, for example, the cases of Victor Nillen and Andrew Markinson, who were both recently exonerated after spending years in wrongful imprisonment. In both cases, their initial appeals were denied because the Court of Appeal was unwilling to acknowledge the possibility of errors in the system, or worse, that those in positions of authority may have acted with malice or negligence. Instead, it is frequently argued that the jury had the right to reach its verdict regardless of whether the evidence they relied upon was inconsistent, flawed, or even fabricated. This demonstrates a disturbing continuity, the same reluctance to admit faults that doomed Bentley's appeal continues to this day. Time and time again, we see the courts prioritize the preservation of their processes over the pursuit of justice, resulting in devastating consequences for innocent individuals. The criminal justice system's reluctance to promptly address or even acknowledge its mistakes raises significant doubts about the ability of self-correct. Although the intention may be to protect its integrity, the actual outcome is quite the opposite, further eroding the trust in the system. By refusing to address its own mistakes, the system ultimately undermines its credibility even further. When the system prioritizes preserving its decision over delivering justice, it creates a perception of infallibility that alienates those it is meant to serve. In contrast, a system that demonstrates accountability and a willingness to right its wrongs strengthens its integrity and earns greater confidence from the public. This attitude does not only concern the judiciary, but it also extends to the executive. It is in fact this obstinate position of infallibility that led Maxwell 5, the then Home Secretary, to decide not to commute Bentley's sentence. On the 25th of May 1972, following the movie and the book to which we referred earlier, the then Home Secretary Reginald Moulding, during a House of Commons debate, was asked whether he was prepared to recommend a public inquiry into the circumstances surrounding the trial and execution of 19-year-old Bentley, to which his response was, although there are some understandable discrepancies in detail in the accounts of witnesses of the confused events on the warehouse roof, the essential facts of the shooting was clear. There is no information before me to cause me to think that the verdict of the jury was wrong. Derek Bentley's family never wavered in their efforts to seek justice for him. After the passing of his parents, his sister Iris took up the fight, determined to expose the injustice in Derek's case. In 1991, thanks to Iris's relentless pursuit and a media investigation by Thames TV, new evidence came to light. The investigation uncovered a number of witnesses who had not been called during the original trial and whose testimonies contradicted key police evidence. This new information prompted Iris to bring the case to the attention of the then Home Secretary Kenneth Clarke, seeking a royal pardon for Derek Bentley. However, in October 1992, Clarke declared that there were no sufficient grounds for granting a royal pardon. It later emerged that Clarke had made his decision without directly hearing from the newly discovered witnesses, raising serious concerns about the fairness of the process. Undeterred, Iris Bentley challenged the Home Secretary's decision through a judicial review. The High Court sided with her, allowing the review to proceed, marking a significant step in the long battle for justice. These then led to a royal pardon on the 30th of July 1993, which was recommended to the Queen by Michael Howard, by then Home Secretary's successor to Clarke. The pardon, however, was limited to the sentence and did not quash the conviction. However, Iris Bentley's action did not rest there, and in April 1997, an application was made to the newly established Criminal Cases Review Commission to refer the case to the Court of Appeal. The CCRC referred the case to the Court of Appeal in November 1997, and the case was heard in July 1998. Before I go into the details of the Court of Appeal's decision, if you are finding this video interesting, please like it, and if you have not done so already, subscribe to our channel. Our analytics tell us that 82.1% of our views are from non-subscribers. Subscribing is free and will help us in accomplishing our mission to highlight the shortcomings of the criminal justice system. Now, turning to Bentley's appeal application, the basis for the appeal rests primarily on two key aspects: the judge's summing up and new evidence regarding Bentley's mental status, particularly how it influenced the statement he gave to the police upon his arrest and his testimony during the trial. The Court of Appeal allowed the appeal and quashed the conviction as it was deemed unsafe. However, it is important to note that the Court of Appeal's view was that on the evidence presented at trial, we conclude that a properly directed jury would have been entitled to convict. They did not find the discrepancy in the police account of events particularly troubling, and whether the appellant shouted the infamous "let him have it, Chris," or whether he knew that Craig had a gun were matters for the jury to decide. However, the court found that the jury had not been properly directed. The judge's summing up was deficient not only as to the standard of proof and the burden of proof, but also in terms of balance. The court found, in our judgment, however, far from encouraging the jury to approach the case in a calm frame of mind, the trial judge's summing up, particularly in the passages we have quoted, had exactly the opposite effect. We cannot read these passages as other than a highly rhetorical and strongly worded denunciation of both defendants and their defenses. The language used was not that of a judge, but of an advocate, and it contrasted strongly with the appropriately restrained language of prosecuting counsel. Such a direction by such a judge must, in our view, have driven the jury to conclude that they had little choice but to convict. At the lowest, it may have done so. In our judgment, the summing up in this case was such as to deny the appellant that fair trial which is the birthright of every British citizen. As per the direction given by the trial judge on joint enterprise, they found the direction to be correct. However, the trial judge did not go, say the court, into appropriate details insofar as Bentley's defense at the trial was concerned. Bentley's defense at the trial rested strongly on the assertion that there wasn't any joint enterprise to resist arrest by violence. And even if, contrary to his assertion, there had been any such joint agreement, he had dissociated himself from it, as demonstrated by the absence of any struggle or resistance or attempt to escape following his arrest, his compliant surrender of the weapons on his person, and the fact that he was under arrest for a significant period before Police Constable Miles was shot. The absence of a judge direction on this important part of Bentley's defense was in fact argued in his first appeal in 1953, but the argument was rejected on the basis that Bentley himself, during cross-examination, when he was asked whether he was under arrest before the shot that killed PC Miles was fired, he said that he was not arrested. The Court of Appeal stated, "We are not, with respect, persuaded by that reasoning. The Crown case throughout was that the appellant was under arrest, or technically under arrest, which must be the same thing, at the time when Police Constable Miles was shot." And it is very difficult to see how any answer given by the appellant could have had any bearing on the legal question whether he was under arrest or not. In any event, when asked in cross-examination whether he was not under arrest at the time, he simply answered, "I was standing there, sir. It is quite true that for much of the time after his initial seizure, he was not physically held, and he agreed that he had been free to run away if he had wanted to. But this was in itself evidence of potential significance supporting the suggestion that for him the criminal enterprise was over." We feel bound to say that in our judgment, the Court of Criminal Appeal failed to grapple with that ground of appeal which should have succeeded. For all the reasons given in this section of the judgment, we think that the conviction of the appellant was unsafe. We acquit accordingly allow the appeal and quash his conviction. It must be a matter of profound and continuing regret that this mistrial occurred and that the defects we have found were not recognized at the time. As far as the fresh evidence was concerned, we are not going into the details of the material that the court excluded, which included ballistic evidence as well as a statement from Christopher Craig and from his legal representatives. However, the Court of Appeal accepted and allowed fresh psychiatric and medical evidence as well as linguistic expert evidence. As far as the medical and psychiatric evidence was concerned, its acceptance was, however, somewhat conservative. The court highlighted that most of the evidence was available at trial and could have been adduced by the defense. The court also noted that though it would have been right for the jury to know more than they did about the appellant so as to be able better to assess his role in the expedition, his conduct in relation to Craig, and the evidence on how his statements came into existence. On the other hand, we do not believe that the importance of the missing material should be overemphasized. As per the new linguistic evidence, this was said to be relevant in relation to the issue of whether or not the appellant was asked questions when his statement was obtained by the police. The linguistic experts concluded that, contrary to what was stated by the police, Bentley's statement was unlikely to have been produced without questions being asked. The Court of Appeal agreed with the experts. It was suggested that if the jury knew that the statement was obtained by way of questioning, perhaps the phrase contained within the statement, to which the judge gave some importance, namely, "I did not know he was going to use the gun," would in fact simply be taken as an answer to a question, "Did you know he was going to use the gun?" rather than implying that he knew that he had a gun. The court accepted the argument but stated that if the potentially damaging effect of this sentence in the appellant's statement had been the only ground for questioning the safety of his conviction, we doubt if we should have thought it sufficient ground for disturbing the verdict of the jury. For reasons already given in section 2, however, we have already held the appellant's conviction to be unsafe and quashed it. This ground provides additional support for that conclusion. And there you have it. Derek Bentley's conviction was ultimately quashed exactly 45 years and 5 months after he was hanged, following a long and complex journey. These included 3 petitions for mercy to 3 separate Home Secretaries, a judicial review, an application to the Criminal Cases Review Commission, and 2 separate applications to the Court of Appeal. Despite these exhaustive efforts, the truth of Bentley's wrongful conviction was apparent long before his trial even took place. In fact, in our view, there was even insufficient evidence to justify charging him, let alone convicting him, as a part to a joint enterprise to resist arrest with violence. Even if there had been an agreement to use violence during the arrest, for which there is no evidence, that understanding had clearly ended by the time Bentley was apprehended, as demonstrated by his actions. His compliance with the police, his failure to use any weapon in his possession, and the lack of any attempt to flee all indicated that he had no intention to engage in violence. These facts were observable at the scene, Yet, despite the availability of this evidence, the miscarriage of justice that led to his execution was allowed to stand for nearly half a century before being rectified. This case highlights serious flaws and limitations within our criminal justice system, particularly when it comes to miscarriages of justice. The fact that Bentley was convicted despite observable evidence of his compliance with police and lack of violent intent shows that the trial process, including the evaluation of the evidence even before he was charged, was flawed. The case was marred by a rush to judgment and a misapplication of the joint enterprise law, raising questions about the thoroughness and fairness of investigations and legal interpretation in serious criminal cases. The sheer number of legal hurdles that his defense had to overcome illustrates how difficult it can be to reverse wrongful convictions, even when there is clear evidence of error. The criminal justice system's reluctance or inability to promptly revisit and rectify mistakes reflects a concerning rigidity that can allow injustices to persist. The fact that he had significant intellectual vulnerabilities makes this case even more abhorrent. The fact that it took nearly half a century to quash Bentley's conviction illustrates the slow and often unresponsive nature of the criminal justice system. The protracted timeline reveals a system that struggles to correct its mistakes in a timely manner, leading to a prolonged suffering for those wrongfully convicted and their families. I eagerly await your thoughts in the comments below, and I also encourage you to share any stories that demonstrate how these issues continue to resonate today. While the risk of facing the death penalty has now thankfully disappeared, other severe forms of punishment remain deeply embedded in our criminal justice system. Whole life orders, for instance, represent a modern equivalent of a slow execution, and for some, this could be seen as even more agonizing. These sentences offer no hope of release, effectively condemning innocent people to die in prison. I do not want to leave you though on this grim note. Rather, I would like to end with a message of hope. Injustice thrives in an environment of silence and the passive acceptance of wrongdoing. It is crucial that we challenge these wrongs as Iris Bentley did by actively seeking reforms and pushing for meaningful changes with unwavering persistence and perseverance. Real progress is only possible when we refuse to stand by and let injustices continue unchecked. Join us with this effort. Your voice, your action, and your support can help drive the transformation our system so desperately and urgently needs. If you enjoy our videos, like this video and subscribe to our channel to support us in our mission to highlight the shortcomings of our criminal justice system. Join us again as we sit and rise in this unique trial.